Welcome to I Couldn't Help But Wonder Divorce Decoded, the podcast where we untangle the legal, emotional, and financial threads of modern family law one story at a time. I'm Lorraine Silverman, and today we're talking about something you hope you never need. But if you do, you'll need it fast: emergency relief in family court. Sometimes things can't wait. A child isn't returned after a visit, a spouse drains the joint account, a former partner shows up unannounced again. I couldn't help but wonder, what does it actually take to get emergency help from family court? And how fast does the system really move when you're in crisis? The story: the surgeon and the surprise custody crisis. Danielle was a pediatric surgeon, calm under pressure, fully booked for the next 6 months. Her custody agreement had been working until her ex decided he wasn't returning their son after his summer visit. No call, no warning, just silence, and a text that read, "He wants to stay here now." Danielle called her attorney. Within hours, she had filed an emergency petition. By 10 a.m. the next morning, she was in court. And that's when she learned family court may not always be fast, but when urgency is real, it can be responsive. The legal breakdown: emergency relief in New York family court. In New York, you can request emergency relief in family court when there's a serious immediate risk to the child or your safety, or when something happens that can't wait for a standard hearing. Situations that may qualify include a child not returned under a custody order, threats or acts of domestic violence, a parent fleeing the jurisdiction, evidence of abuse, neglect, or substance abuse that places a child at imminent risk of harm, unlawful relocation or interference with parenting time. Your attorney, or you, if you're filing on your own, submits a petition marked emergency with a sworn affirmation describing the situation and why it can't wait. It is important to note that when filing these emergency petitions, the judge could take sworn testimony directly from you that day. This means that you could be sworn in to provide testimony under oath outlining your concerns. Be prepared to explain why the situation is urgent and what the court can do to assist you. If your request is granted, the court may issue a temporary order the very same day or schedule an emergency hearing, typically within a week or two, to give the other party time to appear to explain his or her side of the story. These orders can include temporary custody, supervised visitation, exclusive use and occupancy of the home, or a temporary stay-away order of protection for you and your children. The takeaway: don't wait until it's too late to ask for help. If something feels dangerous, unsafe, or urgent, document it. Act on it. Call your attorney. File the petition. Family court can move faster than you think, but only if you ask it to. And only if you're prepared. Thanks for spending time with me on I Couldn't Help But Wonder Divorce Decoded. Next week, we're flipping the script and taking you behind the scenes into what the court doesn't want to see: the mistakes, missteps, and misbehavior that can sink even the strongest case. Until then, if you're facing an urgent situation involving custody, safety, or access to your child, visit thecdslawfirm.com for fast, experienced legal support.